Hello and welcome to Versio's Q&A Wednesday. I'm your host, David Michalek. Today we're going to be talking about the consumer protection laws that allow us to dispute accounts on our credit report. At the center of everyone's credit repair journey are laws that make this possible. And joining me today is an attorney who specializes in the consumer protection laws that dictate how creditors and credit bureaus report information to our credit report and what they must do when they receive your dispute letter. He's here to give us a deeper understanding of the law that helps us in the dispute process. And of course, he's going to be answering your questions live. Let's welcome the founder of the Price Law Group, Stuart Price. There he
Hi,
is.
thank
All
you
right.
for having me. Hi.
Okay, welcome. So we got
Thank you.
got a handful of people joining us today. And what I thought we would do is start off, Stuart, if you can just take a second and tell us a little bit about yourself and then also the type of law that you practice.
Oh yeah, absolutely. So I grew up in Minnesota. I went to college in Massachusetts, and I found my way to California, and I kind of like it here. I know it's not everyone's cup of tea, but I like it here. Um, and now I am a consumer lawyer. My firm helps people who have debt issues. So we do bankruptcy, or we can help with settlements or restructurings and things like that. And I've been a practicing lawyer for over 30 years. And we do this in different parts of the country. But the emphasis of what we do is helping consumers whose rights have been violated. And it's my job to really go anywhere I can and yell and scream, because most people don't understand their own rights. Case in point, we're going to be talking today extensively about the credit reporting. And as you know, most of you can attest to, there's a report that says that maybe 1/4 of Americans have an error on their credit report. And having an error on your credit report can be a big deal. It can absolutely impact your credit worthiness, how much it costs to get credit, things like that. So being on top of your credit is super important. Now, we all know that, and you're here because you know that. But what a lot of people don't understand, what most Americans don't understand, is we do have consumer protection laws that have some teeth that actually work. But most people don't know that. They might dispute an entry that's inaccurate. It might not get resolved, and then they're like, "Oh, what do I do now?" And they
Right.
don't know that we have these statutes with teeth. So one of the main ones that we handle at our firm is the FCRA. That's what we're here to talk about today, Fair Credit Reporting Act. But we also do a variety of different types. And some of the bigger ones would be, the FDCPA, Fair Debt Collection Practices Act.
Yep.
Excuse me. And we do a lot with the TCPA. That's the Telephone Consumer Protection Act. And that's that thing that says no one can call you on your cell phone with a robo-dialer, an automated telephone dialing system, or a pre-recorded message without your consent. So that's those junk calls. But we use those when collectors call you illegally by using an auto dialer, which of course they do most of the time. So anyway, we love this area. We love helping people with violations.
So one of the things that we spoke about the other day, and this is very important to Credit Versio, we're a platform, we're a free software platform that guides people through fixing their own credit by essentially replacing what a credit repair company would ordinarily do for them. And alongside that, and this goes hand in hand with the repair process, is you got to know how this stuff works. And the conversation that you and I had yesterday, I think this is really something very important to talk about, and why we do these things is that nobody pulled me aside or you aside or anybody in high school and college and said, hey, let me explain to you how important credit is going to be in your life. And if you mess it up, or if something happens to you, if there's a violation, just like what we're going to be talking about, it can have a tremendous impact. It can have a catastrophic impact in a lot of ways. That 3-digit number that we have, that is our credit score, defines so much of what we have, the options that we have in life. And recently I've been referring to your credit report as your reputation report, because it's not really about your credit. It's not only about your credit anymore. Employers look at your credit report. Your insurance company looks at your credit report. Landlord. I mean, there's a lot of people who are looking at that document to figure out who you are, and agree with it or not, like it or not. That's just the world that we live in. So it's really important for us to understand not only how credit works, but also what happens when we have something on our credit report that isn't right, or maybe we don't think it's there in a way that's correct. And that's one of the reasons why we have experts on our Facebook Live, such as yourself, that can go into detail and explain how this stuff works. So maybe give just a little bit of history, or what you think people should know about the Fair Credit Reporting Act and then the Fair Debt Collection Practices Act.
So with the FCRA, Fair Credit Reporting Act, what we need to know is this. Congress has enacted laws to protect us and to protect the accuracy of our credit report. And very, very simply, it sounds like this. If there is an inaccurate entry in your credit report, you as a consumer have the right to dispute that. And the way the dispute works is like this. You send in a dispute, this information is wrong, and here's why. And you send that to the credit reporting agency, which is usually one of the big three. Perhaps in another session, we can talk about how there's actually a lot more people who prepare consumer reports. But for our purposes today, it's the big three. So you send in, you go, hey, this is incorrect. It's not right. Then what typically happens is that the credit reporting agency forwards that information to the furnisher of the information, to the creditor who's reporting something inaccurately. Now, here's the thing that's really important. Under the FCRA, both the CRA, the credit reporting agency, one of the big three, and the furnisher of the information, they both have an independent duty to conduct an investigation. Now, what happens a lot of times is this. You send in a dispute, this is wrong. It's forwarded to the furnisher. The furnisher gets back to the credit reporting agency and says, no, it's correct. And the credit reporting agency rubber stamps it without doing their own investigation.
Right.
And that's a problem because the code's clear. They both have an independent duty. Now, think about this. If all you say is something like, they're reporting me as late, but I wasn't late, or that's information that's inaccurate, that's all you say. The credit reporting agency gets that and sends it to the furnisher. The furnisher says it's correct. They verify the information. Well, there's not much that the credit reporting agency can do because they don't have any additional information. And if you didn't give it to them, how can they investigate it? So really, if it doesn't get fixed, then your primary action is against the furnisher in that scenario. But if you've given enough information to the credit reporting agency, then they're on the hook as well. Let me give you an example.
Okay.
Let's say you were in a debt settlement program. And in the debt settlement program, you had a debt with ABC and you settled it. Okay, great. That's normal. But let's say it's still showing up as due and owing on your credit report. Well, if you have a dispute and the dispute indicates that it had been settled, and maybe, in certain cases, there's additional information you might be able to provide, like here's a copy of the settlement agreement and the acknowledgement that it's been resolved. Now the credit reporting agency has the information they need to do their own investigation. If you've given them enough information, now if it doesn't get fixed, they are on the hook as well. And now you'll have two defendants, the credit reporting agency and the furnisher.
That reminds me, this is a question that we get a lot, and I'm really surprised we haven't gotten it already. So I'll do a little preemptive Q&A on behalf of our viewers. The question is, hey, I sent in a dispute. Let's just say it's a collection that doesn't belong to the person who's disputing. And it's been 31 days, and there's been it hasn't been deleted. If there's no response, no action, is the creditor or the bureau or both, or in this case, a collection company, required to remove that from the credit report?
Let me make sure I understand your question. Is this a dispute that was sent to the credit reporting agency?
Correct. Yeah. So this is just on in line with what our clients are doing in Credit Versio. It is bureau direct. And a question we'll get is, hey, it's been 31 days, 35 days. I haven't heard anything. Doesn't that mean it's supposed to be deleted?
Yes, absolutely. They have to give you the results of their investigation in 1 month.
Hmm.
And failure to give the results of the investigation would be a violation.
Now, how would you, with the CARES Act right now, and with the announcement from the CFPB that came out on April 1st, I suspect this is still in effect, where it essentially said, hey, there's a couple things to keep in mind. One is remember that you can ignore frivolous disputes that come from credit repair companies, and also, even though disputes are supposed to be resolved in 30 days, there aren't any penalties as long as there's a good faith effort. Is that still in effect, or
David, honestly, I don't know if that is still in effect. Even though that probably comes up a lot for people who are trying to resolve their debt and send disputes on inaccurate information, we don't normally prosecute cases where they didn't respond in 31 days, things like that. That's more of an outlier. Even though it sounds
mm-hmm.
like it happens all the time,
Yeah.
it's not something that's exciting at all. Now, if they simply refuse to do anything at all, then of course we would say we disputed it. And instead of saying they didn't fix it and was inaccurate, I'm sorry, no, we would say the same thing. If it's inaccurate and they don't fix it, I don't care if they respond or not. That's why it doesn't come up.
Mm.
Doesn't matter.
Yeah.
If I can prove receipt, I know that the CRA received the information, the
Mm-hmm.
dispute. Either they fix it or they don't, and I'm done. So whether they communicate to me
Mm-hmm.
or investigate doesn't matter. They
Yeah.
simply must fix it if it was an error. By the way, let me go off to the side for one quick second here. I forgot. I want to do a quick disclaimer.
Quick disclosure, right?
Uh, uh, Lawyers, we love to do disclaimers, things like that, and I'm a lawyer, so I'm going to do one. This is informational only. I'm admitted to practice in several federal jurisdictions in several states, and this is a federal practice, the FCRA work. Having said that, I don't know where everyone is today, and you could be all over the country. So I am not providing legal advice today. I'm giving informational information only. Okay, sorry about that.
Excellent. I would be suspicious of you if you didn't do your normal lawyer disclosure.
That's what we
All
have to
right.
do.
Excellent. Excellent. So now we've touched a little bit on the FCRA. Maybe you can talk about the FDCPA.
Yeah. One thing that's really interesting is how a lot of these consumer statutes that are completely independent, have nothing to do with one another, can be a little blendy, and they come up all the
Yeah.
time. And they say different things, and a lot of times it sounds like it's the same thing. But I want to talk about something in the FDCPA that's really important. And again, it's going to sound FCRA-ish because it has to do with credit reports,
Mm-hmm.
but it's has nothing to do with it. Now, most people, if they're working on their credit report, they dispute directly with the CRA, credit reporting agency, and that's when we're in FCRA land.
Yeah.
And that's going to cover virtually everyone here on the call. But once in a while, you might have an issue where you've already disputed it directly with a creditor. You're like, this is wrong, whatever. Before you got into credit rehab, you might have been just trying to figure things out, and you go, this is wrong. And you have sent a letter to a creditor or a collector or a debt buyer or someone, and it says, I dispute this debt. So if you're in that category, listen carefully. Under the FDCPA, if you dispute a debt, and if the entity that you disputed it with, So if it was the original creditor or a collector or someone else, if after receiving the dispute, that entity puts something on your credit report or updates something that's already on your credit report, they must put in language that says something like, this account has been disputed by the consumer.
Mm-hmm.
Failure to do so is an FDCPA violation.
Yeah.
So let's say we're in a world where I'm working with a client. And when I'm working with a client, we see there's an error on the credit report. Of course, I'll ask the right questions. And a lot of people, they might have been working with a debt settlement company who sends out disputes, or a different credit repair company that sends out disputes. If I learn that there was a dispute, then we're going to try to hunt down and determine whether or not they put in the right language. And if they didn't, now I've got an independent FDCPA case against the furnisher of information.
Got it.
So that's pretty neat. But there's all sorts of times when FDCPA can come about in the same world. But David, would you like me to give you like a 2 or 3 minute FDCPA blurb?
Yeah, absolutely. Yeah, let's hear it.
Okay.
And then
All right.
for those watching, if you have a question for Stuart, don't be shy. Put it up on the screen. And then if it's something even relevant to what we're talking about, we will answer it. We might, even if it's not, we might throw it up there. Got any good barbecue recipes? Anything we need to know? We're happy to get it.
Before I go on, I just have to share this because you're talking about barbecue recipes. We all have fantasies. And you're going, where is this going? We all have fantasies. And I have a fantasy, and I might be able to make it into reality, but I want to do a barbecue road trip. I want to drive through the South and stop off in all the right places and eat barbecue. That's my favorite food.
It's funny. My partners here at Credit Versio for my 50th birthday bought me a Rectech smoker. I don't know if you ever heard of Traeger?
No, okay, I don't know about smokers.
It's a grill smoker. It's pure magic. It's the most amazing thing. And so Rectech is I forgot where they're based. I want to say Alabama. I could be wrong. But they have once a year they have this big class where they invite people and it's all outdoors. They show you how to use your Rectech. And okay, we're gonna getting way off topic now.
A little bit. Okay, but I do want to say one more thing. I think it's really important about the FCRA before I talk about the FDCPA, and that's this. Under the FCRA, if there's something that's legitimately incorrect, and if you've disputed it, and if they come back with the answer that says, oh, we verified it with the furnisher of the information, we're not making a change, it's at that moment that you now have a real FCRA claim. Mm-hmm. That means you can go out and engage a lawyer like me, and you're entitled to get it fixed. You're entitled to get damages. So if something happened, you weren't able to rent a place, or you couldn't get credit, or a variety of other things, you get your actual damages. If there aren't any actual damages, you'll still get statutory damages. So we'll call that about $1,000 and attorney's fees. So lawyers like me, we never ask anyone for any money, because if you have a case and we know it right away, usually, we can proceed with the case, never asking for money, because there's a fee shifting statute. That means the defendants have to pay my fees.
Yeah.
So you don't need to go, oh, dang, they didn't change it. There's no need to say that at all. You don't have to do serial disputes. You don't have to dispute it over. If they don't investigate and fix it the first time around, you probably have an FCRA claim, and it's worthwhile picking up the phone to find out, what does that mean for you? Because especially if you have actual damages, I'd hate to see you, end up paying. What if you went and you bought a car, but for the bad credit, you're paying 12% interest instead of 5% interest? That's a big deal. That's thousands of dollars over the life of that car loan. And the examples are unlimited there. Okay.
Very true.
So again, if your credit wasn't fixed and it was incorrect, You probably have a claim. Call a lawyer. All right. FDCPA. FDCPA, Fair Debt Collection Practices Act. That has to do with things that debt collectors either need to do or they aren't supposed to do, things like that. And there's a whole bunch of stuff in that toolbox. But let's just talk about some of the basic ones.
Mm-hmm.
Number one, and this one happens with some frequency, third-party calls. So let's say they're not getting any money from you, and they call someone else. They oftentimes call a parent, a child, a neighbor, a coworker, someone on your reference list, things like that.
Yeah.
So question, can they call the third party? Answer, yeah, they can. For location information.
Right.
But let me tell you two things they can't do. Number one, they can't disclose that it's a debt collection call. So normally they'll say this is regarding a private matter. And if they say that, it's fine. And the second thing, but if they say, oh, this is, so-and-so creditor, no.
Yeah.
And the second thing is they can't call and speak with that same person twice. So imagine they call mom, hey, is David there? He doesn't live here. Okay. And then they call a month later, hey, is David there? Clearly, that's intended to harass the debtor.
Yeah.
If they speak with that person twice. So they can't do that either. And I bring this one up because it happens, somewhat frequently where they're disclosing inappropriately debt.
Yep.
This also comes up even if they call you on your landline at home. Let's say they call you and someone else picks up the phone. There is an exception. They can talk to your spouse, and that's it. But if your child picks up the phone, or your girlfriend or boyfriend or fiance or roommate picks up the phone, and they say, this is Discover Bank, we're calling it whatever it is.
Mm-hmm.
No, they can't do that.
Gotcha.
So think about that one if any one of you are experiencing collection calls. Number two, they can't call too often. Well, what does that mean? What's too often? Unfortunately, it's case specific. I can't just tell you a number. I can tell you some numbers. I can say, let's say they're calling you and you never pick up the phone, but they attempt to call you 10 times a day.
Yeah.
That's too much. That's harassment. 3 to 4 times a day, probably not. In between, it depends. But what we do at our firm is we will talk to you about what your rights are if you're interested in calling us and give you some suggestions. Let's say you told them, you happened to speak with them and you told them about your hardship. This is what happened. I'm completely unemployed because of COVID. And I don't know when I'm going to get another job, but I'll call you if my situation changes. That's just good, smart, common sense communication. You're letting them know what's going on. You're letting them know why you can't pay, and never lie. Always tell the truth. But most of the time, if you're not paying them, it's because you have some sort of a hardship. So tell them about it so they have some information. Now, if you do that, and then they start calling you just a couple times a day, forget about 3 or 4 or 10, just maybe once or twice, there is a theory that we use all the time that's harassment. If you gave them the information that you're unemployed and you don't have enough money and you can't pay the rent, whatever it is, and they keep calling you, well, for what purpose other than to harass you?
Yeah, that's a
So
good
that
point.
could be an FDCPA violation.
I have no doubt that we have a portion of our subscribers who are going through that right now. That's great information.
Here's another one. Threats. Can they call and threaten to sue you and garnish your wages and stuff like that? Yeah, sure. Why not? That's okay. So imagine you get this letter, and the letter says, or on the phone, but the letter usually says, well, we're reviewing your file. If we don't hear from you in 15 days, we will forward this to our legal department who might sue you. Nothing wrong with that. That's okay. Bye. It can't be an empty threat. It has to be a real threat.
Yeah.
So let's say they threaten to sue and 3 months go by and they never sue. Well, now it's an empty threat, and that would be an FDCPA violation.
And now, is that the timeline, 90 days?
There isn't a magic timeline. What we do is let's say if the number is 15 days, we'll take the 15 And we usually add about 90 days because that's
Okay.
about enough time to threaten someone and then follow up and actually do what they're threatening to do. We can't wait forever, right?
Hmm.
So we figured 90 days is about the right time.
Yeah.
We've never tested it in court. These cases tend to settle,
Yeah.
and so it'll be dear collector, you threatened a lawsuit. 3 months have gone by, 4 months, 5 months, whatever. You never did. We think that's an empty threat. Let's talk about it.
Now, does the word might, or referring to our legal team, we may decide to file a lawsuit, does that not protect them?
David, that was a great question, and it does not.
Mm,
And the reason why is this. There is a standard under the FDCPA as to how the communication will be understood.
right.
And what it is, and the test is the least sophisticated consumer.
Right.
So it's not what the FDCPA lawyer, how I would read it, and it's not how you would read it, David, or anyone in particular. It's the least sophisticated debtor. And most courts have determined that in my understanding is most courts would analyze, we might sue you, as the least sophisticated consumer is going to say, oh my God, I'm going to get sued.
I'm going to get sued. Yeah. Someone's going to come
Now,
knocking on my door.
now I can validate that because as a bankruptcy lawyer, which I was the first part of my career,
Mhm.
people came to me all the time freaking out. Oh my God, I got to get this done right away. They're going to sue me. And I look at the
Yeah.
letter and it says
Yeah.
may. They always
Yeah.
say may. But
Right.
people really, when people are experiencing severe debt problems, there's more of a panicky, or there's more anxiety, there's more something. So everything can really bother people.
Yeah.
Um, and yeah, it's they better sue. May means they better sue in
So,
this
okay.
case.
Yeah.
My
That
opinion.
makes perfect sense. And while we're on this subject, this would be a really good time to talk about, if you would, the statute of limitations. Now, a lot of times when people use that, sometimes to them it's kind of a dual thing. They think, well, it's the 7 years until things fall off, and then others will refer to that as, well, how much time does that creditor have to sue me, and how often does that happen? So that's a very kind of nebulous subject to a lot of people. Is they got this debt, they're engaging the credit bureau in a dispute process, and they want to know, will that creditor sue? What does that look like? And what are the laws that are available for creditors to sue?
Okay, so statute of limitations can ultimately be a complex topic and can vary state to state. But I think we can paint some generalities right now, which most people can understand.
Okay.
The statute of limitations and we'll use a credit card company as an example, because
Okay.
I think that's where we are most of the time. The statute of limitations for a credit card company to sue is set by the state. And different states have different timelines. In California, for example, it's 4 years.
Yeah.
And what does that mean? It means generally, with all those disclaimers,
Hmm.
the last time that you paid on that account is when the clock starts. Okay, so I made it my last payment 3 years ago. Well, if the statute of limitations is 4 years, there's one more year left.
Yeah.
All right. Well, let's say it in a 4 year state like California, when my last payment was 3 years and 11 months ago, there's 1 month left.
Hmm.
Let's say someone convinced me to send them $20.
Yeah.
Okay, I'll send you 20. It's nothing. Who cares? Well, the statute of limitations clock just restarted. So it's 4 years from the date of last
All
payment,
over
which is right
again. Yeah.
here.
Yeah. And that's
So
that's great that you explain that, because this is an area of confusion where people think, well, if I send a dispute letter, does that mean that the statute of limitations starts over again?
it does not. It does not. And yes, there is a lot of confusion in this area, but no. It's when was your last payment most of the time.
Yeah.
When
So
was your last payment? And then they can't, and then um, uh, they better sue you within that time. Guess what? Let's say someone sued you outside of the statute of limitations. I'd probably take that case as an FDCPA violation.
Got it.
Why are you
Now,
collecting on debt that you're not supposed to collect on?
mhm,
There are some exceptions to that, but that's important. Let me give you one more piece of information about California. You know how on the collection letters that you get, there's always all those disclosures, and there could be a whole bunch of them.
mhm,
Well, January 1st, 2020, so about 13 months ago, there was a new law passed that said on that date, if the account is already past the statute of limitations,
mhm,
then that collector has to put language, very specific language, something like, we understand that this is past the statute of limitations. We know we can never sue you over it.
yeah,
Basically, we just hope you pay.
yeah, yeah,
And we have seen scenarios where the debt collector did not put that language in, and that would be a violation of that specific statute in California.
gotcha.
So sometimes it's just that they don't put the right information in. But
Yeah,
yeah, they can't sue you after the statute of limitations. Just can't happen.
gotcha. Okay,
And
we've
do
got
they
a long.
sometimes?
Let me read this question here. See if this is something we can put up. So I have late payments on credit card. Uh, okay, well, let's do this. Let me bring Elvin on here. Whoa, here we go. All right. So Elvin, I have late payments in one credit card. So is this 10 late payments? The card had $300 credit limit. I sent a good letter. I'm assuming that's a goodwill letter. Let me put it up one more time. Um, what's the better thing to do? Cancel this card? No, it's completely paid. What is the Elvin? I'm not exactly sure I understand what you're asking. Hold on, let me look at this one more time. Are you saying you sent a goodwill letter? Remove late payments. Okay. Okay, so you sent a. All right. Elvin on the subject. You know what, Elvin? Let me do this. It, Stuart, unless you have something you want to contribute to that, I think that might be something that I address outside of the live. Any input on that?
No,
At
it's
all,
fine.
Stuart? Yeah. Okay. Okay. Yeah, Elvin, I'll take care of that once we end the live. Um, okay. So, Tracy, great question. I was just about to get into something just like this. Okay. Perfect. Good one. All right. When a debt is sold, why is it possible for it to be sold and resold? Does the original creditor get any of that money?
So think about the
Excellent.
debt. Yeah, it's a good question. Think about the debt this way. Think about it as an asset. Think about it as something that you own or have an interest in, like a car.
Mm-hmm. Yeah.
So if I own a car, do you think I should be able to sell that? If I own a house, if I own a toaster, should I be able to sell those things? Yeah. A debt is the same thing. It's just something I have an ownership in. So if I'm a creditor and Tracy owes me $100, Tracy owes me $100, but I can assign that right. It's a well established part of our laws and the way we do business that we can sell our rights to things. So my right to collect $100 again from Tracy is absolutely sellable for sure. Now,
Yeah.
I'm only going to sell it if it makes sense for me to sell it. So if it's an account that's in default, no one's going to pay me $100 for the right to collect $100 from Tracy. That's never going to happen. But
Right.
they might pay me less. They might pay me $10. They
Mm-hmm.
might pay me $15 because there's a risk associated with it. They know that if it's in default, they're not going to get paid in full or every time.
Mm-hmm.
They might be willing to settle with people, whatever. But if they pay me $15 for that account,
Mm-hmm.
the $15 amount is not relevant to anyone. You cannot say to the debt buyer, well, you only paid 15, so I'm only going to pay you. No, no, no. They paid 15 for the right to collect 100.
Yeah.
Now, it'll be easy for them to settle since they only paid 15, of course, and you'll try to settle
Mm-hmm.
with them, but they're not going to go, if they sue you, they will sue you for $100, the full amount that's stated on that account.
Yeah. And if there aren't additional fees that the collection company adds and interest and then attorney's fees, so stuff like that tends to add up pretty quick.
Yeah, but it's too bad you just said that because now I have to talk about the FDCPA again. Um,
Well,
One of the things that we look at as FDCPA lawyers are collection letters from
mm,
third-party debt collectors and debt buyers, because a lot of times they add fees and things like that they're not allowed to do. And if
mm,
they do, and it's not infrequent, it's an FDCPA violation. Let me give you a
ah,
quick example. And it varies state by state, but in a lot of states, um, uh, once the creditors have to do something called a charge off at a certain point in time, usually after 6 months of no payment.
yeah,
And that's a term of art. Charge off is not a write off.
mm,
Charge off doesn't mean you don't owe the money. It's a status. It's an accounting
yeah.
status.
That's a really
So
important point because we get that question a lot: is, hey, it's charged off.
it's not written
Why are you
off.
asking me for money? Yeah, why is there a balance? Why do I still owe money?
Yeah. So anyway, in certain states, once it's charged off, the interest stops accruing.
Hmm.
Not in every state, but in many states. Well, if that's your state law and stops accruing, and they when they do the charge off, it's $5,000. It's $5,000. But it's not uncommon to see it go to a debt collector, debt buyer, where the interest rate, 5,000 at time of turnover,
Right.
accumulated interest since then, $122. Boom, that's a violation. And the nice thing about FDCPA violations, unlike FCRA, is we don't have to dispute anything. We don't have to tell them it's wrong. It's it's if they're violating it, you have a cause of action. Done. So if they
Yeah.
see they put in attorney's fees and interest and collection fees and things like that, if they're not allowed to, you just have a nice, clean, easy breezy FDCPA claim.
Yeah, so that's something to keep an eye on when for the viewers. If you're in the dispute process and you're getting those responses back, or if you're looking at your credit report diligently month over month and you see a collection balance increasing, or if they send you a statement, which happens a lot of times when you do a dispute, you'll get some kind of correspondence from the third party collection company. Watch those balances, see if it's something different
Mhm.
other than what the original creditor had stated as the balance that you owe. Okay, let me take a look at a couple of the comments that we have in here. Yes, Tracy. Well, let's go back to Tracy again. Then we've got another one from Carrie. Maybe we can bring on. Okay, but both the original creditor and the collection account both end up on your credit report. Is it best to go back to the original creditor and pay the debt or pay the collection company? That's a good one.
Yeah, that's a really good one. And I'm not
Tracy, you are two
exactly.
for two today.
Yeah, thank you, Tracy. I'm not exactly sure if I understand all of the question, but I do want to state this. You can't have two different entities reporting the same debt at the same time with a balance. So
Yeah.
let's say the original creditor reports, and then it goes to a debt buyer, and then the debt buyer reports. That's okay, so long as the original creditor no longer reports a balance.
Right.
And that's very important because otherwise the information is misleading. Because someone reading your credit report will think that you owe 5,000 and 5,000.
Mm-hmm.
You only owe the one 5,000.
Yeah.
So it's incredibly important that you look at that to make sure that you don't have two people reporting a balance at the same time. And if so, you have to do a dispute. Really important. But there was,
Yeah.
can you put the question back
Yeah, the
up?
other part of the
Right.
question, well, I'll just bring it back up here again. And I think maybe it's the second part of the question is it best to go back to the original creditor and pay the debt or pay the collection company?
So it doesn't really matter in terms of strategy. Normally, what happens is an original creditor places the file with the collector for a certain period of time. The most common period of time is 4 months. Could be
Mm,
6, could be longer. It's
okay.
usually 4 months. So I do a placement. Sometimes what happens is once it's been placed, you might go to the original creditor. You might go to Discover and say, "Hey, I see that you sent it to a collector, but can I pay you?" Depending on their contract, they might have to say, "No, you have to
Mm-hmm.
work with the collector."
Yep.
But sometimes they'll say, "Yes, you can pay me."
Mm,
But at the end of the day, there isn't necessarily any benefit in paying one or the other unless you can negotiate something better. For example, if the and I'm really, really scared to say this because, and I probably shouldn't, but um, if you have some weird stuff going on in a case and you're asking them for trade line deletion, let's say you're legitimately late. So there's no FCRA case because you're really late. But if there's other weird stuff and you go, okay, collection agency, I'll settle with you if you get the bad mark off my credit report that you put on. Well, then you'd want to deal directly with that credit reporting agency who put the bad mark on. They won't control what Citibank or Discover does, but they can control their own stuff. Now, generally they don't remove bad stuff, but sometimes they do.
Yeah.
But if you haven't, something was wrong, like, hey, you didn't send me the letters you were supposed to send me. Let's say they weren't compliant with something or another, then yeah, they might remove it for you. Now these collection agencies, they do it a lot of different ways, but usually in the first month that they reach out to you, they haven't reported it yet.
Right.
So I advise everyone, once it gets to a collection agency, try to resolve it. Call them, try to settle it, try to do something with it before it hits your credit report. Because generally within the first month or two, you're going to be fine on that additional person putting something crappy on your report.
Yeah. One thing we've noticed too, and I'm on board with you 100% about collection companies not offering a lot of pay for delete, but boy, I'll tell you what, as soon as COVID hit, we're seeing a lot of that, especially the big guys like LVNV and Midland and Enhanced Recovery, more than happy to do a pay for delete. Oh, just to put a little bit more meat on the bone with the question that Tracy was asking, because this might be along the lines of what she was thinking as well. If not, Tracy, I'm just putting words in your mouth. But I think what the strategy is there is, hey, listen, if I can get, we'll use Discover again, which is what the example you were using. If I go to Discover and I own $5,000, it shows a zero balance on my credit report, but I've got Midland Funding who bought the debt, and now it's showing, let's make it easy and say it's $5,000. Now, if I go to Discover and say, hey, listen, can I settle the debt with you? Does that rescind that trade line, that account with Midland? Don't they no longer have permissible purpose if I've settled the debt with Discover? Doesn't that disappear? The collection, the third-party collection.
If the debt is resolved, then no one can report that it has a balance owing. That's all. So if Midland had already been reporting it in some sort of a default status, in some derogatory status, that's okay. So if it gets settled, the derogatory doesn't go away. It's just the balance goes away.
Gotcha. So you're saying that trade line, even though it was settled with Discover, it was once with Midland, the trade line will remain and just show a zero balance?
Usually, Discover would then report to Midland either that they're taking the file back, the assignment back. But Midland's not the appropriate example because Midland's a debt buyer as opposed to a debt collector. Generally. Right. So can we switch it to a debt collector?
Sure, and let's just explain the difference between the two, because that's really important for the viewers.
Yeah. So normally, when you're behind on a debt, you're 30 days, 60 days, 90 days behind, that credit card company will collect from you. And as you get further in debt, in terms of timelines, 30, 60, 90, it goes to different departments where they become more aggressive. Like if you're 5 days behind, they're super sweet. Oh, Mr. Smith, I'm sorry, you're having a hard time. What can we do for you? But when you're 90 days behind, they're not super sweet anymore. But at some point, they're going to make a decision. They usually will hire third-party a collection agency or a collection law firm. There's no difference between a collection agency and a collection law firm for our purposes. They're all third-party debt collectors.
Okay.
That means they have an assignment. They have been hired by the original creditor to collect on behalf of the original creditor.
Right.
The money they collect goes to the original creditor. They get their cut, but it goes to the original creditor. Period. Now, at some point, most credit card companies, when it's in default enough, what's enough? Maybe it's been in default for 1 or 2 or 3 years, and they've tried 2 or 3 different collection agencies. They didn't get any money. They bundle those up and they sell them in bulk to debt buyers.
Yeah.
So if you sell it to Midland for 15 cents on the dollar or 2 cents on the dollar, whatever, it doesn't matter what it is, they now own the debt. And the original creditor, Discover in our example, is done. They have nothing to do with that debt anymore. They can't collect on it. They can't take any money. If someone calls about it, they have to say, this isn't our account anymore. It's been sold to Midland.
Yeah, got it. Okay, very good. All right. So let's see if we have a question here. We're coming up on, almost 50 minutes. This is really flown. This is a lot of great information. Okay, Carrie, as an example, let's see. I can't read. Let me just put it up on the screen here.
Okay.
Ample radiology company sells your $59 debt to a collection agency. You send the $59 check to radiology company. They cash it, a check, but you have a debt for collection still on your account for $59. Okay.
That's a total, complete, classic example. And the way I read that is you paid the debt to someone, and it still shows up as a debt being owed.
Yeah.
They can't do that.
Mm-hmm.
That, if it's just limited to the credit report, I'm gonna slow down for a second because I'm gonna make 2 different conversations out of it. FCRA. If it's still listed on your credit report and it's wrong because it shows a balance, that's something that requires a dispute, and that will fix it. Remember what I said, one dispute, if it doesn't get fixed, it's a probable FCRA claim.
Yeah.
But the other part I want to make sure you understand is the FDCPA component. We talked about a couple different things that happen under the FDCPA, although there are many more. And one of them is you can only collect the correct amount. So if an account has been paid and someone, and I don't care who it is, original creditor, debt collector, debt buyer, anyone, and someone is sending a bill for something that's been paid, that's an FDCPA violation. No disputes required. You can't collect on a debt that doesn't exist. So if you got a letter from anyone after you paid asking you for that amount of money, let us know. That's an FDCPA violation. If it's on your credit report, which I suspect it is, then you dispute it one time. And if it doesn't get fixed, you have an FCRA violation.
Excellent. All right. So I could do this all day. I love this subject. This is great information. You can see we're both passionate about
David,
this.
I feel like
this topic.
Only 4% of the information is out there so far. Yeah. So there's so many reasons to keep these sorts of things going. And I know you do.
Yeah, absolutely. Okay. Let's see. Okay. We'll do this. Okay. Cash check on hand. It's still on. Okay. All right. Well, this is a great opportunity to have a segue, Stuart. Let's just say somebody wants to get a hold of you and ask some questions. How would they go about doing that?
Probably the easiest way is to just email me directly and let me know what state you're in, and just a brief description of what's going on so I can make sure it gets to the right attorney. My email address is price@pricelawgroup.com. So that should be pretty easy. Price.
That's what I was going to say. It doesn't get easier than that.
You can also call if you like, 800-884-6000. And we'll get your call to the right place. There's never going to be a charge to call us, to pick our brains, to ask us questions. Don't worry about it. There are no dumb questions. Part of our mission, part of our joint mission really here is making sure that Americans are educated about their rights. I'm not worried about whether your questions will lead to a case for me or not. I'm interested in making sure that your rights are intact and that you understand them, because most people don't. Yeah. Yes, once in a while I'll find a case, and once in a while I'll make money on that case. That's great, and so will my clients. But most of the time that I speak with people, it's informational, and that's great because I need more and more people to know what their rights are.
Yeah, and that's great. And that's what I really love about this segment with FDCPA and FCRA attorneys is that you guys are available for people to ask their questions. And should it lead to a case, there's no money out of pocket. There's already dollar amounts that
Hmm.
have been set aside under the law that take care of whatever fees are accumulated as a result of you having to represent the client. All right, excellent. Thank you very much, everybody, for joining us today. Stuart, thank you so much for being on the Credit Versio's Q&A Wednesday. And
Thanks for having me.
uh, Carrie, you know what you might want to do is just I'll respond to your question once we're done with the live, and I'll get you Stuart's info. Or Stuart, you can pop your information on that on our page as well if you like. Thank you very
Okay.
much, everybody. That's going to be a wrap for today. We'll be back next Wednesday with a Q&A, and I'll look forward to seeing you guys there. Thank you so much for joining me.